Good evening, everyone. We welcome each one of you to our Advocate on Record Aspirants Academy. Let me move on to the topic for today. And before that, it is our regular practice that we recite preamble. We feel that preamble is our unity and divinity. So therefore, I request each one of you to recite preamble along with me. We, the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. Now let us move on to the topic for today. Very, very important topic, not only for AOR examination, but also for our practice. Every topic which has appeared in our AOR examination, very important. Now, lecture number 38. 37 is successfully completed. Now, 38. What is the difference between professional misconduct and other misconduct provided under section 35 of Advocates Act 1961? Dear friends, I must admit that so far we have delivered 37 lectures. Though we make extensive research, intensive research, but to answer this question, it has taken nearly 7 to 8 days to find out the relevant case on this point. So therefore, dear friends, if it is delivered within 15 minutes, don't think that don't give less weightage. Yesterday I took this case when it was 1 o'clock in the night. I tell to myself, when we are awake, let others peacefully sleep. Right? So therefore, when somebody is working for 10 people, that means it gives us the self-satisfaction. That is the purpose of life. I took it around 1 o'clock in the night. Why do I say so? The reason is, it is not something that we nearly taken down 20 judgments, but we felt what is should be given the best to our aspirants. Because always we were taught, it is not half an hour or 1 hour seminar or lecture. It is 1 hour plus 25 people are involved. That means 25 hours, 1 day is completed. If it is more than 30 minutes, 30 hours. Who am I to waste your time? So I must consider your precious time. It is 1 day lecture. We calculate every 1 hour's time. So therefore, I respect each one of you, each of your time. Please consider, dear friends, this I am going to tell you how to approach this topic. Because I have seen the journey we went through. I want you to travel along with me to find out the answer. So this is a question asked in our AOR examination. What is the difference between professional conduct or other misconduct under Advocates Act, more particularly section 35? Now, how do you approach yourself? Nobody is there to guide you. You ask yourself, which act we must refer? First question. This basic question we will understand. Definitely Advocates Act we will refer. Go to the index. And question itself says section 35. So we will straight away go to section 35. I am going to make you to travel along with me how to find answers to those questions, dear friends. Let us read section 35. Punishment of advocates for misconduct. Subsection 1 says, where on receipt of a complaint or otherwise a state bar council has reason to believe that any advocate on its roll has been guilty of professional or other misconduct, it shall refer the case for disposal to its disciplinary committee. Now they have referred guilty of professional or other misconduct. Conducting a strike, boycotting the court, making disrespectful submission before the court, or you receive the fees for filing SLP, you don't file it. If there is a duty mentioned to you under Bar Council of India rules, there are professional conduct, etiquette mentioned in the Bar Council of India rules. When you violate those rules, it becomes professional misconduct. When you retain your client's pre-brief until he is paying you, that means we don't have right to lien over the case brief. So that is professional misconduct, because the rule itself says don't do this. If we do it, it is professional misconduct. What is other misconduct? That is the question staring at our face, for which I would like to draw your attention to Bar Council of India rules, dear friends. Under Bar Council of India rules, when there is a rule, Bar Council of India rules means, that means where have they framed this rule? Advocates Act under section 49(1)(c) empowers the Bar Council of India to frame rules. Section 49(1)(c) of the Advocates Act, which empowers the Bar Council of India to frame rules, and more particularly on Part 6, Chapter 2 of Bar Council of India rules. Dear friends, this preamble, by heart it, because in professional ethics, for any question, you can try to answer this, give this, because this will be suitable for all the questions. So likewise, prepare certain format where for any question you can apply. This you can write, you can take it from me, you can read this and you write it. That will definitely impress our examiners. How beautifully the preamble says of chapter 2, an advocate shall, it is not may, dear friends, this is going to answer us what is other misconduct. Therefore I am reading this. An advocate shall at all times, they are not saying during the court hours or within the court premises, at all times comfort himself in a manner befitting his status as an officer of the court. So when you are not even in the court, you are at home, or when you are walking on the road, but still you are an officer of the court, an officer walking on the road. That is how you have to feel. You are an advocate, a privileged member, therefore extra responsibility. Responsibility comes with power, extra responsibility. So an advocate shall at all times comfort himself in a manner befitting his status as an officer of the court, a privileged member of the community. Community means a group of people. Among the group of people, we are the privileged member of the community, and a gentleman, bearing in mind that what may be lawful and a moral for a person who is not a member of the bar, for a layman, it may be lawful also, it may be moral also, but for a member of the bar in his non-professional capacity may still be improper. So he may be a non-professional capacity. That means an advocate in private capacity, though for layman it may be moral, but for a lawman it may not be moral. Therefore, other misconduct in private capacity, in personal capacity, or for a member of the bar in his non-professional capacity may still be improper for an advocate, without prejudice to the generality of the foregoing obligation. An advocate, though there are certain restrictions we have given, without prejudice to the generality of the foregoing obligations. Till now we have stated about the obligation of the advocate. An advocate shall fearlessly, This is very important, dear friends. While assisting the honorable court, you should fearlessly, this is your right. An advocate shall fearlessly uphold the interest of his client and in his conduct conform to the rules hereinafter mentioned both in letter and in spirit. Not only read it, but also practice it. The rules hereinafter mentioned contain canons of conduct and etiquette adopted as general guides. What we have stated is duty towards the court, duty towards the client, duty towards a colleague, towards the society. It is only the guidelines. It is only the general guidelines. Yet, the specific mention thereof shall not be construed as a denial of the existence of other equally imperative, though not specifically mentioned. Whatever it has mentioned, we have to follow it. Whatever is not mentioned, that means doesn't mean that you can do anything else. You cannot do that. Therefore, at all times, an advocate remains as an officer of the court, a privileged member of the community, and always a gentleman. What may be lawful and moral for a layman may not be lawful and moral for a lawman. So, therefore, dear friends, extra power, extra privilege comes with extra responsibility. Now we have understood to some extent that even in his private capacity, whatever he does will also come under other misconduct. Now let me take you to what are the disqualification to become an advocate, or when an advocate, when he wants to enroll, he cannot enroll. There are some sections are there, dear friends. I will take you there. 24 capital A. After this, we will find out the answer. 24 capital A of the Advocates Act 1961, which talks about, which deals with disqualification for enrollment. No person shall be admitted as an advocate on a state roll. No person shall be admitted as an advocate on a state roll. A. If he is convicted of an offence involving moral turpitude. B. If he is convicted of an offence under the provisions of the Untouchability Offences Act 1955. C. If he is dismissed or removed from the employment or office under the state on any charge involving moral turpitude. Explanation. In this clause, the expression state shall have the meaning assigned to it under Article 12 of the Constitution, provided that the disqualification for enrollment as aforesaid shall cease to have effect after a period of 2 years has elapsed since his release or dismissal, or as the case may be, removal. 2. Notwithstanding anything contained in subsection 1 shall apply to a person who, having been found guilty, is dealt under the provisions of the Probation of Offenders Act 1958. Now let us understand what is moral turpitude, dear friends. It has been defined in one of the cases. Name of the case is in the matter of Mr. P, an advocate. Not to disclose his identity, the nomenclature, the title has given us in the matter of Mr. P, an advocate, AOR 1963, Supreme Court 1313. AIR 1963, Supreme Court 1313. Section 24A speaks about moral turpitude. The expression moral turpitude should not receive narrow construction, and wherever conduct proved against an advocate is contrary to honesty or opposed to good morals or is unethical, it may be safely held that it involves moral turpitude. Let me give you one example, dear friends. For professional misconduct, you have understood. If you advertise, because the rule says you cannot advertise. If you advertise, that it becomes professional misconduct. You cannot retain lien over the case papers. If you retain, it is professional misconduct. What is other misconduct? Let us test now. For example, you are residing in a society. There, there is a election conducted in the society, because for president, vice president, secretary and executive members in a society, because it is a society welfare association, whatever the society residents welfare association, election is conducted. An advocate is a resident of that society. He was elected as a secretary of the welfare association. There was some storage issue with reference to the tank is concerned. Tank has to be repaired, for which the fund is collected, corpus fund is collected from the all the residents in the society. But instead of constructing a tank for the society, the secretary has constructed a extra room in his home. He has utilized or misappropriated the fund for private interest instead of the welfare of the residents. Now they go and file a complaint, maybe 420 or breach of trust, anywhere before an FIR is registered. Even based on that FIR, or even FIR is registered and trial court has found him guilty, that means he was dishonest. He had misappropriated those funds and he was found guilty and he was convicted. Therefore, dishonest person cannot continue to be in the profession. Therefore, under other misconduct, though he was not conducted or indulged in misconduct in the capacity of advocate, but even an advocate, always an advocate. That is what the rule says. Therefore, he has indulged in his private capacity those misconduct, but still he can be punished. Therefore, other misconduct. Hope it is clear, dear friends. For example, he tries to stab an advocate, is parking a vehicle, and there is a parking issue. They started fighting, and immediately an advocate just picked up a stone or knife and stabbed. Attempt to murder, right? Therefore, it is against, he has acted against the law. Therefore, he will come under professional other misconduct. So therefore, he cannot be continue to be a member of this noble profession and learned profession. So for this, dear friends, I have taken one case law. I will refer one case. This is very important. For getting this case, we have worked for 7 days, dear friends, to get the relevant case. The name of the case is Noratan Mall, N-O, Noratan Mall, N-O-R-A-T-A-N-M-A-L, Noratan Mall, Chauraria versus M.R. Murali and another. I will give you the citation. 2004, Volume 5, Supreme Court Cases, 689. Comprising of Honorable 3 judges, Honorable Justice V.N. Karai, Honorable Justice V.N. Karai was the Chief Justice, and Honorable Justice S.B. Sinha and Honorable Justice S.H. Kapadia. I repeat the citation, 2004, Volume 5, SEC, page number 689. So here, what was the problem? The problem was, advocate was the landlord, tenant, they had an issue. Case was pending. Whenever the tenant came to the court, the advocate did not behave properly. He appeared as a party in person, not in the capacity of advocate. He appeared as a party in person. But once the matter is over, the tenant goes out of the court, he goes and threatens him. He takes his friends, 5 friends, and they say, don't depose the evidence, otherwise we will kill you. And at times, he had attacked also. Advocate attacked the tenant, threatening him not to attend the court. So therefore, tenant got irritated. What is this advocate doing like this? So he made a complaint before the State Bar Council. But State Bar Council, though they have taken the complaint, but they did not find enough material to punish for other misconduct. So therefore he was not found guilty by the State Bar Council. Matter went to the Bar Council of India, met the same fate. He was not found guilty. Again, that complainant came to the Honorable Supreme Court. The argument was, though he was appearing as a party in person, but still in his private capacity, he has attacked me, he has threatened me, therefore he has conducted himself not only under professional misconduct but also other misconduct. So therefore he will come under other misconduct, therefore punish him. So this was the question before the Honorable Supreme Court. Now the Honorable Supreme Court has discussed elaborately about what is misconduct, what is professional misconduct and other misconduct, dear friends. Let me take you to the relevant portions. Para 7. Para 7 deals with, I request each one of you, dear friends, please take out this judgment. Because 7 days work, you are getting it in a minute. Take out this judgment and how beautifully dealt by honorable judges. They have said what is the facts of the case, findings of the State Bar Council, findings of the Bar Council of India, and then submissions made by the advocate for the petty appellant, respondent, then application of law. The entire thing they have written it. We have to only read it. Mother prepares the food, we have to only eat it. So it is already prepared food, you have to only eat it. So please read it today, dear friends. What is misconduct? Misconduct has not been defined in the Advocates Act 1961. That is the issue. Misconduct has not been defined in the Advocates Act 1961. Misconduct inter alia envisages breach of discipline. Although it would not be possible to lay down exhaustively as to what would constitute conduct and indiscipline, which however is wide enough to include wrongful omission or commission, whether done or omitted to be done intentionally or unintentionally, it means improper behavior, intentional wrongdoing, or deliberate violation of a rule or standard of behavior. Then lordships are referring to Black Law Dictionary, a transgression of some established and definite rule of action, a forbidden act, a dereliction from duty, unlawful behavior, willful in character, improper or wrong behavior. Its synonyms are misdemeanor, misdeed, misbehavior, delinquency, impropriety, mismanagement, offense, but not negligence or carelessness. So they have defined, they have taken it from what Black Law Dictionary says, then P. Ramanatha Law Lexicon Dictionary says, then they have referred to several cases, dear friends. This one judgment will give us entire professional misconduct leading cases. They have referred to Prabodh Kumar Bhaumik versus University of Calcutta, in which a professional misconduct or other misconduct committed by a member of the profession should ordinarily be judged qua profession to determine the quantum of punishment. They are talking about the quantum of punishment. And then M, an advocate, that is a case law. Then application of the principle to the present case. And now other misconduct case laws. In Hikmat Ali Khan, dear friends, please make a note of this. Para number 19, Hikmat Ali Khan versus Ishwar Prasad Arya. Let me tell you what is its citation also. 1997, volume 3 SEC, page number 131. I repeat, 1997, volume 3 SEC, page 131. Hikmat Ali Khan versus Ishwar Prasad Arya. What happened in this case? Relevant portion has been extracted in para number 19 of this judgment. An advocate concerned assaulted his opponents with a knife. He was prosecuted and found guilty of commission of an offence under section 307 IPC. In the aforementioned situation, it was held that the advocate deserves extraordinary punishment of removal of his name from the state roll of advocates. He is already punished under 307. Still, he has been removed from the state roll. where he got enrolled as an advocate. So therefore, dear friends, so with this, dear friends, how we have asked ourselves the question, what is the difference between professional misconduct and other misconduct? There is no definition in the Advocates Act to define what is professional misconduct. So therefore, since it has not been defined, we looked for the dictionary meaning and we look for the preamble given under the Bar Council of India rules. An advocate at all times, an officer of the court, a privileged member of the community, and what is lawful and lawful and moral for others may not be lawful and moral for the members of the bar. So therefore, when you, for example, a forced sale deed, an advocate prepares in his personal capacity, still he will be charged under 420 also, as well as there may be a reprimand, suspension or removal from the state bar also, professional or other misconduct. So this is what the journey, this is how you have to ask yourself and find answers to yourself, dear friends. Thank you so much for your patience hearing. I'm really honored. Dear friends, most of the AOR aspirants are part of our WhatsApp group. Now what I'm going to do in future is, anyway we are going to determine what will be the topics for the next session. I'll put it in the group. This is what the topic is. Even you can also make a research. If you find very relevant point, you can give it to us. Therefore, all the points can be seen and we can give the best quality to all our AOR aspirants. Therefore, you can also be a part of the research committee. You can do your work. You can prepare yourself and then you can contribute. Thank you so much.